Hans Kluxman. I'm an attorney in Prescott, Arizona, and I help folks find answers to their legal questions. And today, Don Zavala, another attorney here in Prescott, is speaking to us. And Don, if you care to introduce yourself.
I'll be glad to, Hans. And thank you for having me on your program today. I appreciate that. My name is Don Zavala. I'm an attorney here in Prescott. One of my practice areas is employment law. I do that along with business law. And we're actually here, Hans, today, I believe, to talk about the Families First Coronavirus Response Act. Is that right?
That is. And what is that?
That's a new act, Hans, that Congress passed effective April 1st, 2020, that requires that employers with less than 500 employees provide a special type of leave to their employees in response to the coronavirus problem.
Oh, and what kind of generally are the requirements that employers need to be aware of in terms of informing their employees?
There are several requirements so employees know that this leave is available. The first is you must have a poster. It's a Family First Coronavirus Response Act poster that needs to be placed in a conspicuous location, such as a break room, that all employees can easily access. On this, and that's normal for all of your employment law posters that are required to go up in the workplace. This has a special one attached to it. You also should email that poster along with your policy, I'll talk about in a moment, to all employees, because many employees are working from home and not in the workplace, right. So they need to be informed of their rights. The second is you need a policy, as I just mentioned, that tells employees what their rights are under the Family First Coronavirus Response Act. And that poster, that policy, should list all the different reasons for the leave and how they apply for the leave and how they take it, so employees are informed about that. And the third piece is you need to create a leave form. The leave form should go to all employees along with the poster and the policy, that if an employee wants to request leave under the Family First Act, they would fill out this leave form, and then they would send that to their employer to request the leave.
Okay. And what types of leave are provided for under this new law?
Well, there's two types, Hans. The first is paid sick leave.
Okay.
That is available for a variety of coronavirus-related sicknesses or issues. The second is an expanded paid family medical leave, which many employers might be familiar with the Family Medical Leave Act. That applies to employers with 50 or more employees. The key here is this new special paid family medical leave applies to employers all the way down to one employee. So while most people normally wouldn't be impacted by the Family Medical Leave Act if they have less than 50 employees, they are going to be by this act, or they could be.
Okay. And so can you tell us a little bit about the Paid Sick Leave Act part of that?
Sure. There are actually 6 categories people can take paid sick leave. And the first reason is that the employee has been subject to a government quarantine or isolation order that's related to COVID-19. Of the ones we're going to talk about today, that's the least common one you're going to find, but it is there, so you need to be aware of that and make sure you comply with that. The second reason is that the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. Oh. That's fairly common. We see that fairly often. An employee goes to their healthcare provider. The healthcare provider says, you have symptoms that look like COVID-19. I want you to go home and self-quarantine. Your employee tells you that. They get this leave, send them the leave form, and make sure that you comply with those rights and provide that leave opportunity to them. The third is the employee is experiencing symptoms of COVID and they're seeking a medical diagnosis. That also is very common because employees don't necessarily know once they start getting sick whether or not they have COVID, actually have COVID or some other type of symptom. So if you get that phone call from your employee, then they're entitled to have some leave if they want it. Fourth is the employee is caring for an individual who is subject to a government quarantine order and or has been advised by the healthcare provider to self-quarantine. So the individual has a family member that's been advised to self-quarantine. They're under an order, and you then need to give them leave for that reason as well. The fifth reason is the employee is caring for his or her son or daughter. If the child's place of school or place of child care has been closed due to COVID-19 precautions. That's pretty common. We saw that quite a bit in April and May. And as we'll talk just a little bit more in a minute, now it is summer as we make this recording. So schools are closed. And people might think, well, then this is not applicable. But don't go so quickly. It could be. If your child normally went to summer school and summer school is closed, or if your child normally went to summer camp and summer camp is closed due to COVID, this provision may apply. So for that one, if that comes up, you're going to need to make sure you find out what the facts are so you can apply it correctly. This one about the son or daughter school being closed also will tie in just a minute to the Paid Family Medical Leave Act we're going to talk about, because those two provisions are interrelated in some ways. We'll get to those in just a minute.
Okay.
Here, the last reason is kind of a catch-all they put in at the end. Any other substantially similar condition. So that's pretty broad. Be aware it could involve things that you wouldn't normally expect. But if somebody is having COVID-type symptoms or flu-like symptoms, this becomes an issue you have to be careful with.
Okay. Now, if you qualify, if an employee qualifies for this paid sick leave, well, what does that entail then? What is the employer's responsibility then?
Well, the employee is entitled to up to 80 hours of paid sick leave.
Okay.
And I say up to on purpose because not all employees are full-time. If it was a full-time employee working 40 hours a week, they would get the full 80 hours in that 2-week period, 10-day period. There are also many part-time employees, and in that case, they would get a pro rata share of that 80 hours. So whatever it is that is calculated under the Act as being their average pay, their average hours worked, that's what you would apply as paid leave. And there is a formula in the statute for that you would need to familiar yourself with to make sure you do it right.
Okay. And is this leave, does this replace, Arizona has sort of a paid time off sick leave policy. Does this new paid sick leave replace that or change that? Or?
That's a great question. It's in addition to, and I think that's important to remember. The state law, we do have in Arizona, a paid sick leave in Arizona. Employees actually get to choose which one of these they're going to take. And it's not in replace of, it is in addition to. So let's say an employee has sick leave of 30 hours under the paid Arizona sick leave law. And they can use those 30 hours. They can also then use these up to 80 hours prorated if we're part-time and have a longer period of time if they qualify under this act.
Okay.
The reasons you get paid sick leave under Arizona law and this act are slightly different. There's some overlap, but they are slightly different. The employee gets to choose and take whichever one that applies they want to take.
All right. So you said there were two components of this new law. One was the paid sick leave, but the other was, it sounded like an expansion to the FMLA, that leave act. What can you tell us about that?
Okay. The FMLA being the Family Medical Leave Act.
Okay.
That is something most employers who have 50 or more employees should be familiar with, but it provides certain leave rights under specific conditions. This paid family medical leave applies regardless of the number of employees. So just because you're under 50 does not mean you're exempt from this act. It still applies. And it goes all the way down to one employee. That leave under the Paid Family Medical Leave Act is that employers must provide 12 weeks of job protected paid leave for employees who have been employed at least 30 calendar days and are unable to work or telework to care for a son or daughter under age 18 if their place of school or place of childcare is unavailable due to a public health emergency.
Okay.
You'll recall our governor in Arizona declared a public health emergency in April. All of our schools closed. A lot of people became covered under that provision. So this works in conjunction with the paid sick leave. And we'll explain just a little bit more how those two pay concepts come together. But the point to emphasize here is we're now in the summertime here in Arizona. It's June, and most schools are currently closed. Well, you do have to be careful here because there could still be summer school and summer camps that would qualify your employee for leave under this provision. So under the Paid Family Medical Leave Act, the first 10 days are unpaid. The second 10 weeks, because that's the remainder of your 12 weeks, is paid at a rate of 2/3 the employee's regular rate of pay. Not 100%, but 2/3, with a cap of $200 per day or $10,000 in the aggregate. Now, what's interesting about this is I said to you, the first 10 days are unpaid. That's under the Paid Family Medical Leave Act. Note that provision we just talked about in the paid sick leave law. You get 10 days paid if your child's school is closed or daycare provider is closed due to a COVID or a public health emergency. You get 10 days. So that combines with this to be the first 10 days you could be paid 100%. And the second 10 weeks, you're paid at 2/3 subject to these limitations. So they wrote it so that they work together cohesively on those leave.
Okay. And you said that even though generally the FMLA employers thought of as applying to not the smallest of employers, but this provision applies to all employers, correct?
That's
under
correct.
500 employees.
Right, that's correct. Under 500 employees, this will apply. There are some exceptions, and we'll talk about those in just a minute. But it will apply to employers under 500 employees, so all the way down to 1. That could possibly be the case. Now, there is one limited exception on the job protected leave, meaning you have to reinstate the employee to their prior job when the 12 weeks is over.
Okay.
There are some exceptions that may apply if it's a small employer under 25 employees. Then there are some exceptions on restoring to the same job. So for those, you'd want to make sure you check with your counsel to find out how that specific provision applies. And indeed, with all of these, you should check with your legal counsel. This is not meant to be legal advice for anybody, of course. It's meant to be informative. So on all of these things, check with your attorney. But that's the general way this would work, is that if it's under 25 employees, there are some exceptions to the protected leave rights.
Now, I think some employers probably have in the back of their mind as well is that the FMLA applies for 12 weeks. So is this 12 weeks that you're talking about here, the first 2 unpaid and then 10 weeks at the 2/3, is that an additional 12 weeks? Is that the same 12 weeks?
That's a good question. It is not an additional 12 weeks. The 12-week cap for total FMLA leave still applies. So if an employee has already taken 6 weeks of family medical leave, and they now need to take paid family medical leave under this provision during the same leave year, they only get a total of 12. So they would only be eligible for 6 more weeks of paid family leave until your new leave year begins. And that's a whole nother discussion about how you calculate that. But until that leave year begins, they only get that 6 additional weeks. So it's 12 total during that leave period.
Okay. You know, Don, a lot of this sounds, I don't know, it sounds complex. And I was just wondering if you would suggest that employers maybe get it scheduled now. I know they've been dealing with a lot this year, to have their policies and procedures reviewed to update for these new laws and things like that. Do you think that that would be warranted for small employers?
I do, Hans, and it's very important to make sure your policy manuals keep up with changes to the law. Here, this is a new leave policy, and it has to be read and seen in conjunction with your current leave provisions. So what you want to make sure you do is go to your local counsel, your legal counsel for employment work, have them review your policy manual, make sure that you have a policy for this act and that that policy works in conjunction with your other current leave provisions.
And then I've heard in the news that some of these provisions, there may be some government help to help employers with some of these costs, but that is pretty complicated, I imagine. And do you have any suggestions for small businesses trying to figure out what the overall economic impact of this will be to them?
Yes, I do. There are tax credits, and the law is rather complicated. And what I would suggest folks do is talk to your accountant, find out how you can apply those tax credits. It is taken the amount of money you pay your employees under this, subject to certain rules, can be deducted from future payrolls, but your accountant can tell you when and how you get to do that and how that should be done. So you want to be very careful to do that correctly, but you also don't want to miss it because it has a wonderful financial benefit to the company.
Okay, so maybe then in recap, my takeaways from this is an employer's got to be sure that they notify their employees of the existence of some of these programs so that their employees can take advantage of it. And then that two, the employer kind of needs to coordinate these new laws with its existing policies and procedures and its financial and tax planning. Did I take away the proper things?
Those are two very good takeaways. The last takeaway I would just want to mention for folks to look into is there are two exceptions to these requirements for employers under 500. And those exceptions are certain healthcare providers and emergency responders have been excluded from the definition of employee. And the second is, what that does though, before I move to the second one, it allows, if they properly qualify, the employer has the option to opt out. How it qualifies is very specific and very careful analysis. We ran into this a number of times. And who qualifies for this exemption would need to be talked over with your counsel to make sure you're doing it correct. And the second is, if your business is under 50 employees and requiring this type of leave would jeopardize the viability of your business as a going concern, Congress put in an exception that you then don't need to comply with this. But I would beg to ask a question, which is, if you get a tax credit for any payments you make under the Family First Coronavirus Response Act, exactly how is that going to jeopardize the ongoing viability of your business? You're getting reimbursed from tax benefits. I think that provision is going to be very hard to prove, and it'd be very difficult to show, but it is there. And if a business thinks they're in that category, they should check with their local counsel to find out whether or not they might qualify for that.
Okay. Well, Don, you've given us quite a bit of information here, and I guess consult with your counsel, your professional advisors if you own a business is about the best takeaway to recap it all. And I want to thank you for spending time with us today. And again, thank you very much, Don.
Hans, I was glad to do it. It's been a pleasure doing this. I hope it's helped people. It's an important act. We need to make sure we all work through this virus situation together. And employers should check with their attorneys to make sure they apply all this correctly. I'm glad to be able to be here.
All right. Thank you. Goodbye, Don.
Goodbye, Hans. Thank you.